Hey everybody, this is Mr. Moppin coming at you. This is an AP Gov video focusing in on topic 2.11, taking a look at checks on the judicial branch. So when we talk about, the judiciary, one of the very important questions is, how should the court interpret the Constitution, and thereby having some type of impact on policy making as a branch. This is definitely one of the more contemporary debates, focusing in on the role and the responsibility, the scope of influence that the court should have. And when we take a look at this debate, there's basically two camps with regards to this issue. Those that support judicial restraint and those that support judicial activism. Now, those that support judicial restraint believe that the courts have or should have very minimal policy-making responsibility. That it is not the job of the courts to basically dictate what should be done in terms of government action. They tend to believe that that is the job of Congress to make the laws and the president to sign off on bills that become laws and enforce those laws. And the reason being is that those people are chosen by the public, whereas federal judges are not chosen by the public. And so the basic, gist of it is that when it comes to applying the Constitution, it really is centered on the issue of what was the intentions of the founders when they, wrote that part of the Constitution. What did they intend? What were they thinking? Not trying to put it through a modern prism. Not as if, what if people were today writing this part of the Constitution. Antonin Scalia, in many respects, showcases this very conservative notion of interpreting the Constitution when he describes that the Constitution is like a statue. It is what it is. You can't go back and remake it once it's already been made. So for example, if you're taking a look at the Constitution's 14th Amendment Equal Protection Clause, that was written in the wake of the Civil War. It was ratified in 1868, and when you look at that part of the Constitution that talks about equal protection of the law, somebody would argue, at least a member of the court that supports judicial restraint would say that, when we talk about equal protection of the law, this is clearly applying to people of color. This is applying, clearly to African Americans as an attempt to try to have citizenship and equal protection of the law following the end of slavery, and in the attempt of trying to create a new America, and particularly a new South. Judicial restraint scores would say then that the 14th Amendment Equal Protection Clause really doesn't apply, for example, to homosexuals. The argument being that the folks that wrote the 14th Amendment were not thinking about equal rights for homosexuals, be it marriage or adoption rights or, things like that, when that was written. Therefore, it should not be applied to that group. Now, note, it's not saying that those that support judicial restraint are homophobic or anything like that. That's not the point of the example. It's just saying that that is not the court's job to make that assumption when making that type of interpretation. In other words, if states want to do that on their own, if there's a constitutional amendment that wants to be added, fine, so be it. But conservatives like Scalia would argue that that is, or what Scalia would have said if he's still alive, would say that that would not apply to this group. Now, the opposite of this is judicial activism. Judicial activists argue that the court has a very important responsibility to use its power in government to interpret the Constitution in a way that does things that that Congress or the legislative branch and the executive branch can't do or won't do, but nonetheless should still be done. And this commonly includes a modern interpretation of what the words say in the Constitution. In other words, supporters of judicial activism would say that, the Constitution is not a statue. It is a living organism that grows and evolves over time, and it must be applicable to modern themes. If it's not applicable to modern themes, then kind of, what's the point of this document. So the idea being is that courts have a responsibility to interpret the Constitution through a modern lens and to use its power to make up for injustices that the other branches will not focus in on. For example, if you are looking at the issue of racial segregation, particularly in public schools, southern states at the time, their state legislatures and their governors had no interest in promoting integration in the public schools. It would require the court, through Brown v. Board of Education, to step up and say, no, this is what has to be done. The legislative and the executive branches are not doing their job to apply the Constitution properly. Therefore, the court was saying at the time, you must apply it in this way, meaning that you must apply equal protection to children of color in public schools. That is what must be done. If Scalia, crystallized the idea of judicial restraint, you could probably give some credit to Charles Evans Hughes for crystallizing what a judicial activist interpretation of what that concept means. Hughes is quoted to have said that the Constitution is what the judges say it is, that it is not made out of stone, it is malleable, and the job of the courts is to tell the public what this document means. This is what it is. In other words, what is freedom of speech? It's what the courts ultimately say it is, not the Congress, not the president. It's ultimately the court's responsibility because it is the court's job to interpret the Constitution. Now, critics would argue that this is too much of an injection of judicial authority in realms that the public does not have a voice in, which is a very, credible argument. Judges, remember, federal judges are not elected by the people. They're not held accountable by the people. They serve for life. And so there is a sense of, kind of maybe hijacking the ability of the legislative branch to make the laws and the executive branch to sign those bills into law. Many liberals tend to be in support of judicial activism, where more conservatives tend to be in support of judicial restraint. Now, at the end of the day, is there a singular right answer to this debate? Of course not. That's why there's a debate. It's a matter of philosophy and opinion. But you must, be aware of the differences between judicial restraint versus judicial activism. Now, that being said, when we take a look at some critical limitations on the court's authority and power, this kind of gets into the checks of the federal courts. Once again, remember that in our legal system, we operate on we operate using an adversarial system of law. In other words, courts cannot have an influence unless the case is brought to them. If there is not a lawsuit made, if it does not get appealed, so to speak, to the Supreme Court, then a court cannot have influence. Courts cannot just simply look down and say, like, for example, the U.S. Supreme Court cannot just look at some case in some state and go, ooh, that's interesting. We're going to, on our own, decide unilaterally what this means and what the ruling should be. That doesn't work that way. There's a procedure through our court system that would allow for maybe the court to hear a case, but unless it goes through that procedure, the Supreme Court cannot really have any influence. Going hand in hand with this, the courts can only have influence regarding an actual case, an actual justiciable dispute, an actual lawsuit, for example, that has been filed. You cannot have a situation where the courts can just make a ruling on something based on a hypothetical. Like, for example, let's say that, there was actually, we know that President Trump, during his term in office, had made the argument that that presidents could pardon themselves under Article 2 powers. Well, does the court agree? Is that allowable? Does the Constitution allow for that? Well, here's the thing. The court can't weigh in on it because nobody's filed a lawsuit regarding that. And you can't file a lawsuit regarding that unless somebody is arguing that they have been damaged by it. Well, you've never had a president pardon themselves, so it's never actually happened, so nobody could be damaged by it. Therefore, it's a hypothetical and not a justiciable dispute. Therefore, the court has no official ruling on that. So it has to be an actual situation, not a hypothetical. On top of that, we've mentioned previously that the courts like to walk away or stay away from what are considered to be political questions. The idea being is, if this is something that is best decided upon by the representatives of the people, then they tend to kind of walk away from it. One example of this in particular is foreign affairs. The courts do not really get involved in terms of, should the United States have, pulled out of Afghanistan? Was that a violation of somebody's rights? And, the court would say, well, that's a political decision. That's a political question. That's not really the court's role to kind of step in and say, what a certain policy matter should be in that regard. So if it's deemed by the court a political question, they're going to stay away from it. And then, of course, some other, checks that you're probably obviously familiar with. In order to get to the courts, the federal courts, you have to be appointed by the president, and then you have to be confirmed by a majority of the Senate. So unless you have, the approval of the president and the Senate, you're not going to be a federal judge. We've talked previously that Congress dictates the size, structure, and jurisdiction of some aspects of the federal court system. So, the structure of this branch really is beholden to Congress, except for the existence of the Supreme Court. Don't forget that just like members of the executive branch, federal judges are also held liable for possible impeachment and removal from office. It's never happened to a Supreme Court justice. We've never had one removed. We've had one impeached, but never removed. But we have had lower federal court judges that have been impeached and been removed. Now, these are all things we've kind of talked about before, but something that's new is that I did want to add to the list is something called senatorial courtesy. This is a tradition. Now, note, this is a tradition. This is not a law. It's not in the Constitution. It's just a tradition. What this does is apply to what are appointments for the lowest federal courts, the district courts. And let's say, for example, there is an opening in the U.S. District Court of Southern Ohio. Senatorial courtesy dictates, as a tradition, that the president would then go to a senator of that court's vacancy, assuming they're of the same political party, and would get feedback from that senator from that state where the vacancy was in terms of who should probably fill that lower court seat. So, for example, if there was a vacancy on the U.S. on the U.S. Court of Southern Ohio, Joe Biden, who is a Democrat as the president, who has the ability to appoint who would fill that vacancy, would then go to the Democrat senator from Ohio, that would be Sherrod Brown, and would get his opinion. He would ask Senator Brown, who do you think would be good to fill the spot, yada, yada. They would take into consideration. It's not a lock. It's not a done deal. Presidents are not, duty bound to make that recommendation as their official pick. But in many cases, it is what happens. So that's what's called senatorial courtesy. So the Senate has some additional impact in the appointment process, not just the confirmation process. But remember, this only applies to the lowest courts, the district courts. It does not apply, for example, to the U.S. Supreme Court. Okay, well, we will leave it there for now. When we come back, we'll take a look at part 2 on checks on the judicial branch, especially taking a look at the selection process for federal judges. We'll see you next time. Bye.